court, defense counsel, ladies and gentlemen of the jury. Am I going to have the right words to honor the victim in this case? You see, in trial, we throw around names, photographs, but what this case is about a living, breathing human being. This case was about Yolanda Williams, a mother, a daughter, an aunt, a cousin, a friend, a beloved member of the community. And she is no longer with us, ladies and gentlemen, because this defendant killed her. He made a choice, he made a decision, and he killed her. Your job is going to be a difficult job. No one is going to make light of it. Your job is a solemn one, but an important one. It is one that is going to require great bravery and courage, but each one of you in jury selection stated you would follow the law. And the law in Florida is the death penalty exists. And it's true the defense will tell you you never have to vote for the death penalty. But each one of you told us you would fairly weigh it, and if you felt like the aggravating factors outweighed the mitigating circumstances or factors, that you could vote for the death penalty. I want to walk you through the process and what your role will be. We've already determined the legal culpability in this case, ladies and gentlemen, through the first verdict. Now is the time to make the moral culpability. What is the moral culpability in this case? This is the process you're going to go through, and the judge will instruct you. Has the state proven at least one aggravating factor beyond a reasonable doubt? The second step, are the aggravating factor or factors sufficient to warrant the imposition of the death penalty? Third step, do those aggravating factors outweigh the mitigating circumstances or factors? And fourth, should the death penalty be imposed? You have a four-step process, ladies and gentlemen. Let's walk through a little bit of how it works. What the judge is going to tell you, these are aggravating factors. They increase the gravity of the crime or the harm to the victim. They're statutorily enumerated. And the judge is going to instruct you, we have four of them, and I'll go through them with you in a moment. We have to prove these beyond a reasonable doubt, and you unanimously have to find the aggravating factors. Let's just be clear and understand. You have to unanimously find that we've proven an aggravating factor beyond a reasonable doubt, but you do not have to be unanimous in your recommendation for death. Okay? We understand the difference there, just so we understand. There will also be the mitigating circumstances, and this is what the judge will tell you. Mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstances of the offense. You'll have all these instructions to go back with. The defendant does not have to prove that beyond a reasonable doubt. They just have to prove it by the greater weight of the evidence. And the judge will instruct you that. This is what is super important, and I know Ms. Schwartz talked about it. The judge is going to instruct you that the process of weighing aggravating factors against mitigating factors or circumstances, it's not a mathematical calculation. It's not 2 is greater than 1, 3 is greater than 2. It is how much weight does one have over the other. For example, You may have a semi-tractor truck. It weighs a lot. You may have multiple other cars that they don't have as much weight. And one tractor trailer can overweigh the other vehicles. Keep that in mind, ladies and gentlemen, and I'll talk through you why I believe in this case and why we believe the state has proven that to you. What the judge is going to tell you is if fewer than 8 jurors vote for the death penalty, the court must sentence the defendant to life. However, if 8 or more of you vote for the death penalty, your recommendation for the judge, it's not binding, but the judge will give it great weight and deference. Keep that in mind. The judge doesn't just willy-nilly. Whatever you say, she will take in great deference to, ladies and gentlemen, and give great weight to. Let's talk about our aggravating factors. And then we're going to go through them step by step and show how the state has proven those and the weight of those. Jermaine Williams was previously convicted of a felony involving the use of threat of violence to another person. Jermaine Williams was previously convicted of a felony and was on probation at the time he committed this first-degree murder. The capital felony was especially heinous, atrocious, and cruel. And finally, the murder was committed in a cold, calculated, and premeditated manner, without any pretense of moral or legal justification. The judge will give you all these instructions. I'm not making them up. So you'll have detailed instructions. Let's go through the first one. Jermaine Williams was previously convicted of a felony involving the use of threat or violence to another person. This is the false imprisonment from July 19, 2022, where he was convicted. It actually occurred on January 23rd, 2022. And we'll walk through from that what it was. This is what y'all looked at. This is the conviction, offense of false imprisonment. It's right there. You can actually see it on the date that it's dated by the court. So you have that conviction. That's in evidence. I submit to you that's evidence beyond a reasonable doubt of his conviction for that. Okay? But we didn't stop there, ladies and gentlemen. Here's where it gets a little bit more. So y'all told us in jury selection that in order for you to make a recommendation, some of you felt like it was determined what prior behavior they may have had. Well, in this case, ladies and gentlemen, Jermaine Williams' behavior in 2022 was atrocious. He had his wife in the kitchen, and what does he do? Does he just beat her in private? Does he just hide it for everybody? No, he had the audacity to go wake up an 11-year-old boy, bring an 11-year-old out to where his mother is, and smack his mother 5 to 6 times in front of him. Every time she pleaded for him to let the child go away so they didn't have to see it, he then smacked her again and again. That has great weight to it, ladies and gentlemen. Not only that, you heard, he made her take off her nails, and if she didn't take them off, he was going to take them off with a hammer. He said this in front of his 11-year-old child. Does that have great weight? You better believe it does. Jace goes back to his bedroom. Do you think it ends right there? No. What does he do? Does he stop beating up his wife? No, he grabs her hair, pulls it out, and knees her in the head several times, all while his son can see from his bedroom. You heard the testimony from the officer who responded, Deputy Hershey. When he arrived, she had bruising not from him, he would know that, but bruising on her face, her wrists, and her hair was pulled out, consistent with what Jace told you. There's no doubt that that crime was a felony involving the use of threat or violence to another person. Now, the defense may want to get up here and say, well, that false imprisonment, there was no violence involved. I submit to you, ladies and gentlemen, you were here, you had the opportunity to see Jace get on the stand and explain exactly what happened. And when he did that, there's no question, no doubt that this false imprisonment involved violence or the threat of violence. There was testimony about a sign or stick that was not broken earlier and then broken the next day when Jay saw it, or when he went out at 3 in the morning. And he made his kids go outside and try and make their mom come back in after she fled to the grandparents' house. Think about that. Does that aggravating factor have weight? Absolutely. And I would submit to you, it's not just weight, it's great weight. This is a situation where he beat up his wife and held her there with his child present. And he had other children in the house. And all because he was pissed off because his son sang at a funeral? Ladies and gentlemen, that aggravating factor has great weight. And I would even submit to you, I could sit down right now, not explain any more aggravating factors to you, and I would submit to you that this aggravating factor, in and of itself, far outweighs any of the mitigation that you're going to hear about. Far outweighs it. But we're not going to stop there, because you get not one, you get 2, 3, 4 aggravating factors. And as we go through them, you will see that the aggravating factors in this case far, far, far outweigh any mitigation. Second aggravating factor was Jermaine Williams on probation at the time. Simple answer is yes. Here is the evidence that was put in for you. He was placed on probation in July. This is the conditions of it. 18 months followed by 30 months probation. Okay? So that's 48 months from 2022. And what did the probation officer tell you? He told you his probation might have ended at the beginning of this year. So at the time in 2022, August 2nd, the probation officer told you he was on probation. We have proven this beyond a reasonable doubt. I would submit to you, ladies and gentlemen, someone who is on probation and then commits an offense like this, that aggravator, that gets great weight, ladies and gentlemen. This is one that deserves it. It was put on July 19th by the judge, Judge Perkins. Great weight. Those are the aggravators that don't deal with the actual crime here. But let's talk about the ones that do, because aggravator number 3 is probably the most disturbing that we've seen in this case when you watch the videos. What the judge is going to tell you, that it was heinous, atrocious. Some people like to think it's and, like we have to prove all 3. It was either heinous, atrocious, or cruel. And I'll walk you through that. What does that mean? This is the definition the judge will give you. Heinous means extremely wicked or shockingly evil. Atrocious, outrageously wicked and vile. Wicked, morally very bad. And then the judge is going to tell you, cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment with the suffering of others. So let's walk through this case. And the judge will tell you its additional acts to show the crime was conscienceless or pitiless and unnecessarily torturous. So, unnecessarily torturous. We're going to talk a lot about that, ladies and gentlemen. Yolanda Williams, for 26 minutes, had her life flashing in front of her. Jermaine Williams, at 8:12 a.m., came out of that house with this knife. We know Yolanda Williams feared for it at that moment because we saw her backing up we saw her trying to get away. He goes toward her and moves in a quick fashion. And then we see him go to town, right? Pain is atrocious and cruel is when someone also realizes of their impending death. The fear going through their mind at the time this is happening. You get to use the definition of this to see what was going through Yolanda's mind. Was she scared at the time? Was she afraid? Was she fearful? Did she think she was going to die? Absolutely. All of those. And we'll walk through it. And the judge will tell you it's not going to be limited to physical pain. It's psychological or emotional. So as he's stabbing her, think of the emotion that she had at that moment. Think of the fact that her son comes out of the house in front of her. That's a factor you get to consider too. This is what he did to her. This was 5 minutes after it began. She wasn't dead, still alive, still breathing. She suffered great pain. The medical examiner told you that. Dr. Steen told you when you get stabbed, it hurts. We all know you get a paper cut, it hurts. 19 to 20 stabs, suffered great pain. Was it torturous? You better believe it. That's a factor as part of heinous, atrocious, and cruel. Let's talk about her injuries. Number 1, through muscle and soft tissue of the neck. Number 2, soft tissue and fat. These wouldn't kill her, but the question is, are these also painful? Do you think she knows when she's getting stabbed through soft tissue that that's not going to kill her? We got 3, right breast. So this goes from the back all the way through, cuts through muscle 6, which aids in the respiration, pierces the diaphragm, nicks the liver, cuts the stomach. It's fatal, but she possibly could have survived with medical attention right away. If it was just that one injury, that's what the doctor said. Well, we know that's not just her one injury. Was that unnecessarily torturous? Absolutely. Suffer great pain? You better believe it. Number 11, cuts through the intercostal, 6, middle lobe of the lung. 4.9 inches into her. That's a fatal stab wound. This knife, 8 inches. That stab wound went 5 inches of this knife into her. It went from the back of her all the way to her lung on the other side of her body. Do you think that was painful? Torturous? You better believe it, ladies and gentlemen. Soft tissue number 12. Soft tissue 13. 14. Soft tissue goes to the intercostal muscle, cuts the left lung, that should be cut, sorry, cuts through the diaphragm, 5.5 inches, possibly lethal. So the one before was 4.9. He shoves this even farther into her. 5.5 inches of this 8-inch knife goes through her to the other side of her body. Cuts the left lung, the diaphragm. Do you think that's painful? Torturous? You better believe it, ladies and gentlemen. Left upper back. Fractured the 8th rib. Fractured. Cut the left lung. Cut the pericardial sac. Went into the outer layer of the heart. Possibly fatal. Think that was painful? Think that was torturous? Absolutely, ladies and gentlemen. We're not done. Soft tissue stopped next to the thoracic spine. Think that was painful? You better believe it. Number 17. Fractures left 9th and 10th ribs. through her lung and into her kidneys. 4.7 inches into her body. Think it's painful? Torturous? Mind you, it's not like she just had one stab wound. She got stabbed over and over again. 18, soft tissue. 19, soft tissue. 20, fractures a rib and then goes and cuts the left side of the diaphragm. Think that was torturous? Think that was painful? Better believe it, ladies and gentlemen. And it wasn't just painful, it was great pain. Torturous, unnecessarily. All because this defendant sitting right here decided he was going to kill his wife. Just because this was a defensive wound and it cuts the tricep, that doesn't mean it wasn't painful and torturous. Look at the gash here. We're not just talking about a little cut. This goes into the fatty tissue. That is painful, ladies and gentlemen. Suffered. And that is unnecessarily torturous. And what this shows us is, you've seen in the video, she's fighting for her life. Arms up, legs up. He continues. He does it. And he's so goal-oriented and goal-driven that he doesn't just stab willy-nilly. He tries to move her arms and her legs so he can get a direct hit on the most vital parts of the body. Heinous, atrocious, and cruel, you better believe it. Number 5, another defensive wound. Goes through soft tissue. And what did the doctor tell you? It's indicative that during that stab, she's moving her arm and it makes marks in there. You think that's torturous? Do you think that's great pain? Absolutely. This is his handiwork. Nobody else's. Number 7, number 8, they could be connected. If they're connected, what that means is the knife went all the way through the arm, out the other side. While she's fighting, she's trying to live. She sees her son. You think that's torturous? You think that has great pain? Certainly, I can't argue that they were connected, but Dr. Steed said it can be 1 stab wound or 2. I would submit to you if it's 2, it's probably even worse, because that means she took 2 different stabs. But if it's 1, it's still terrible. It goes through her whole arm to the other side. Unnecessarily torturous. Number 6. And then we have below there, I think that's number, I want to say 7. Her hand. And you heard testimony from different individuals that the defendant knew she had grabbed the knife and was holding it, trying to stop him from killing her. You think that's painful? You think that's torturous? It cut through the bone, not the bond, the bone. She grabbed that blade, hit it with defensive wounds. Painful? You better believe it. Unnecessary tortures? Absolutely. These pictures are not the best, but it's just showing his actions that day. First one, you could see him. You see that knife? You see that? You could see him with the knife right here over his wife. You see him on top of her. You see him over her again. We see him having her pinned down. We see once again him in control, him stabbing her. It's almost like in this picture, it looks like he's looking right, staring right at her. You think that's heinous, atrocious, and cruel? You think she doesn't know of her impending death at this moment? She's bleeding from all extremities while he's attacking her? She tries to get away. And then he throws her on the ground and attacks her again. She's on the ground with her legs up, fighting for her life. You think she doesn't know her life might be coming to an end? You think she's not scared? You think she's not frightened to death? You think she doesn't know that this guy is about to kill her? Heinous, atrocious, and cruel. Look at that. He tosses her like a rag doll. She falls onto the ground. The doctor told you she had a contusion in the back of her head. So cavalier, just trying to get in there so he could kill her. Jace comes out. So goal-oriented when Jace comes out that he tells Jace, actually points to him, go back there, get out of here. And when he does that, he then re-engages with his wife. And if you remember the video, Jace comes over and pushes him away, right, before he can stab her again. But then he pushes Jace away. And then right in front of Jace, right where her, Yolanda can see it all, he goes and stabs her. At least 2 times, if not 3 times. This is when the police arrive.
He can't breathe. He can't breathe. He can't breathe. He can't breathe. I can't breathe.
Seriously.
Can't breathe.
Hey, can someone give me something?
Can't breathe.
Someone give me something. We need chest seals and everything. We have like 30 stab wounds.
Can't breathe.
Think it's painful? Think that's torturous? You think she knows she's about to die? She can't breathe. Not once, not twice, not 3 times, not 4 times, not 5 times. At least 6 times she's held the deputy. Torturous. Great pain. Pain is atrocious and cruel. And that's not the only person she said it to. You remember the paramedic? We talked to the lieutenant. What does she say when she's in the back of the ambulance? I can't breathe. And then what does she say? We know she knows she's going to die at this moment. I'm going to die. Great pain. Torturous. She knows her life is flashing through her at that moment, and she's going to die. That, ladies and gentlemen, is heinous, atrocious, and cruel. Jermaine Williams inflicted that on her, and she didn't die instantly. She didn't have the pleasure of just dying quickly. She lived for 25 to 26 minutes with that torture, with that knowing in the back of her mind that she was going to die. 26 minutes. We could set a clock for 15 seconds. A 100 times that is what Yolanda had to sit there realizing what was going to happen to her. The thought that she'll never see her family again, her children. Torturous? You better believe it, ladies and gentlemen. This is just our time with them, and it goes to show. She's still alert at 8:27 in the ambulance. Still alert 8:29. Still alert 8:30. 8:35, heart starts to slow down, but still responsive. 8:38, she's done. 25 to 26 minutes later, she's dead. She was conscious and fighting for her life the whole time. This is heinous, atrocious, and cruel, ladies and gentlemen. Complete indifference. No pity. This aggravator, ladies and gentlemen, it deserves great weight. I could sit down right now, even just with this one aggravator. Let's separate out, there's no others. And this aggravator far, far outweighs any mitigation. This one aggravator alone. But that's not how your process is going to work. you get to weigh all of the aggravators together. Okay? This aggravator holds a strong weight in this case. That video is worth 1 million, if not 1 billion words. We know what was going on in her mind. We know what she was thinking. We know she knew she was going to die. Her last 26 minutes on this earth. That aggravator deserves great weight, ladies and gentlemen. Finally, the last aggravator. And you may say, you know what, you go back there and Ms. Schwartz and Mr. Lewis, I just don't think the cold, calculated, and premeditated applies here. Throw it out. If you don't think it applies, I submit to you the other 3 aggravators. And in fact, like I submitted to you, aggravator number 1 and number 3 in and of themselves are more than enough or way more to override any sort of mitigation in this case. But let's talk about cold, calculated, and premeditated. This is what the judge will tell you. Cold means it was a product of calm and cool reflection. So let's think about that. So as Dr. Demery told you, the defendant was calm. Did he run into the house to go get a knife? No. He walked into the house, just strolled on in there, walked calmly back, ladies and gentlemen, with the knife in his hand that he had selected. The knife that was the big 8-inch knife for killing someone. And he continued to walk up to his wife, didn't run at her, and he only moved quickly when what happened? When Yolanda tried to get away. He advanced quickly to catch her. That is absolutely calm and cool reflection. And the judge, you previously heard, it doesn't have to be days in waiting. It's up to you to make a decision about whether these factors apply. Calculated, a careful plan, or prearranged design. So it doesn't have to be both of those. So you may go back there and say, you know what, there was no careful plan, it wasn't done ahead of time. I submit to you in this case, it was a prearranged design. In that 1 minute and 10 seconds, he prearranged and he designed it to go get this knife. He didn't go inside and come out with a little scissors. He didn't go inside and come out with a rope to try and whip her with. He went inside and he came out with this knife. And he didn't just backhand her when he got out there. He immediately went to trying to stab her. I submit to you that's a prearranged design to commit murder. Of course, it's for you all to decide, ladies and gentlemen. What I submit to you, the state has proven that beyond a reasonable doubt. If you think that we haven't, set it aside. There's no doubt that the heinous, atrocious, and cruel, prior violent felony, and being on probation more than outweigh any mitigation in this case. And I'm not just saying outweigh, it substantially outweighs any. And we're going to go through it in a minute. And this is what the judge will tell you. Let's fly through this. That's them outside, and then he walked calmly inside. They were just talking outside. Comes out a minute later, minute and 10 seconds. Cold, calculated, premeditated. And we just watched this with Dr. Demery, so we'll go past this. But that's him attacking her. Over 90 seconds. Cold, calculated, premeditated. You can also decide, ladies and gentlemen, that some of the elements of cold, calculated, and premeditated occurred when he was actually attacking her. And I submit to you, based on his way he acted, that is a plausibility. Because he didn't just go up to her and take it and stab her over and over and over again 19, 20 times. He took his time in a careful plan to try and find a location that she would die if he stabbed her. He aimed for the back, he aimed for the chest and the neck. He didn't just go willy-nilly. It was a minute and I want to to say 45 seconds or 50 seconds, but you can stab someone like this, 20 stabs in 20 seconds. That's not what occurred here. You get to consider the circumstances of when that murder occurred, ladies and gentlemen. These wounds, cold, calculated, premeditated. Cold, calculated, premeditated. I submit to you, ladies and gentlemen, the state has proved that beyond a reasonable doubt. And then waiting to find the location of the stabber as she fights him. Tells his son to go away. Time to reflect. Stabs her right there in front of the sun. Still going after Yolanda. Only stops because his dad tells him he's going to kill her. I submit to you, ladies and gentlemen, that's cold, calculated, premeditated. Careful plan, prearranged design, great weight, ladies and gentlemen. Let's talk about the mitigators in this case. You've heard the testimony the last couple of days of some mitigation in this case. Let's go through that and see if it's been proven and how much weight should be assigned to it. The loss of his brothers and mother. That's sad. It's very sad. How much weight does that deserve, though? How many people who lose their mother and brother go and kill their wives and stab them over and over again? I submit to you, ladies and gentlemen, that was proven. No doubt, I'm not going to deny it. But it deserves little weight. Very little. Has been helpful to neighbors in the community. Fine. What kind of weight does that deserve in comparison to what he did in this case? Little weight, I submit, ladies and gentlemen. Has a talent for mechanics and is mechanically inclined. Sure, that was proven. He fixes cars. How much weight do you get for that? I say little weight. Organizes community and family celebrations. How much weight? Does that deserve that much weight? A little weight. Substantial repairs to his mother-in-law's house. Very thoughtful, very nice. How much weight in comparison to the crime does that deserve? I submit to you little weight. Made repairs to his own parents' house. I submit that's little weight. Received corporal punishment as a child. He did get punished as a child. I guess we give that a little weight. I'm not really sure that that deserves any weight at all. But being fair to him, let's give him a little weight. His dad disciplined him when he was bad. This next one, I'm not sure I understand it, so you guys can take it for what you are. I don't know if it's proven or not proven. And even if it's proven, I don't know what weight you give to the fact that the man is always in charge of the home and the word is the last word. Not even sure what that means, but you guys feel free to give it whatever weight you think. Fear of rejection and abandonment. How much weight does that deserve? Very little weight, I submit, ladies and gentlemen. Lack of appropriate coping mechanism. How much weight does that really get? I would submit to you little weight. And helped others in need. Sure, he was nice, he paid for some groceries in front of him. We get some weight for that, but I submit that's little weight in comparison to what happened in this case. Now let's move on to experts. The judge is going to tell you, experts are like other witnesses. With one exception, they allow them to give an opinion, but you can disbelieve any of their testimony just like any other witness. So we had Dr. Olander testify yesterday, and we put a net back on the stand today, and you might be wondering why. And the reason was because Dr. Olander, in her testimony yesterday, said that there was domestic violence when the defendant was growing up, and that was reported by the mother-in-law. That's just patently wrong and not true. You heard from Annette Anderson, she's the mother-in-law. Did she tell you she reported that to anybody? No. Did she report that she told that to Dr. Olander? No. So I tell you that because you have to really be skeptical of what Dr. Olander is saying. Because obviously she got something very wrong. But let's talk about Dr. Olander's testimony. First off, she diagnosed the defendant with a personality disorder characterized by narcissistic, borderline, and antisocial traits. So let's go through that. So narcissistic is someone who has an innate, inflated need for admiration. He likes himself, okay? An unstable identity, okay? Hypersensitive to shame. I mean, lots of people get upset when they're shamed. Lack of empathy, the lack of caring of others. Was this proven by Dr. Olander? Maybe. Let's say it was proven. What weight does that deserve, though? Does that deserve any weight as a mitigator? And I submit to you, ladies and gentlemen, it deserves no weight at all. The fact that he doesn't care about other people, how does that mitigate the crime he committed today? Or not today, back then? How is that anything that gets any weight? So I submit to you, it has maybe been proven, but it deserves no weight at all. Let's move on to borderline. Unstable relationships. We know he had an unstable relationship. He liked other women. Fear of abandonment again. Life instability and heightened anger and rage. Why would any of that stuff mitigate the crime? What weight does any of that have in this case? And I submit to you, there's absolutely no weight to it all. The fact that she diagnosed him with borderline, that has no weight. Then she diagnoses him with antisocial. A disregard for others' rights. How is that a mitigating factor in this case? Was it proven? Sure, she diagnosed it. Proven. But what weight should we give to the fact that he disregards the rights of others, he's deceitful and manipulative? How is that a mitigating circumstance that deserves any weight at all? And I submit to you it deserves no weight. None at all. That's Dr. Olander's testimony from yesterday. Let's go through the rest. She only met him for 4 hours. Amazingly, Dr. Olander gets hired on this case. This is what's pretty fascinating. So, Jermaine Williams is 52 years old. Never diagnosed with anything in his whole life. And then miraculously, when she's hired by the defense to come in, she comes up with this diagnosis of it. But even so, let's say this diagnosis applies, none of it deserves weight. I submit to you, no weight at all for those. Let's move on to the rest of her testimony. An inability to deal with loss or self-control. I mean, I don't know that we really had a lot of testimony about that, but what weight does that really get when you can't deal with losing your wife so you kill her? It doesn't make sense. But it was proven, but I submit to you, no weight. The first-degree murder was committed while Jermaine Williams was under the influence of extreme mental or emotional disturbance. Now, this is contested with Dr. Demery coming in, and you all heard all the testimony. Was he under extreme mental or emotional disturbance? Dr. Olander wants you to believe that because, well, let's talk about it. This is her reasons why he was. He had significant power and control over her through the long years they were together, but that was starting to decline after his arrest. So the fact that he controlled her for all these years, and then now, August 2nd, she was starting to pull away, that somehow makes it extreme emotional. She had the ability to take trips, and she couldn't do that in the past. So that makes it extreme emotional. Planning on leaving the weekends with family and friends. The rage was an accumulation of an intense emotional feeling of loss, and her not wanting to ride with him was another clear piece of evidence that his attempt to make the relationship work were not happening, and he was losing her, and she was becoming more and more independent. What? How does that go to extreme mental or emotional disturbance? It just doesn't make sense. He was preserving his self of sense as a man. That was the underlying basis of his elimination of the person who had devastated his sense of self. That was the last thing he had left to preserve. So the fact that he was pissed off that she was not bowing down to anymore and his manlyhood was being affected put him in an extreme mental or emotional disturbance. Does that really fit with that definition? Absolutely not, ladies and gentlemen. Dr. Olander's testimony, trying to fit this in as an aggravator, it just doesn't make sense. And the only way to preserve his sense of self as a man, the king of his family, and maintain a sense of identity. What? So because he's king of the house, he's king of the world, he's the man, and because his manhood was taken away, that made him extremely mental or emotionally disturbed? I submit to you, ladies and gentlemen, it does not fit under that definition any which way. And I submit to you, based on Dr. Demery's testimony, when Dr. Demery testified, and he told you his actions were cool and calm. And Mr. Barrett spent all this time, well, he was walking, you don't know what he walks like. No, but Dr. Demery interviewed him and listened to his statements. And what did he tell you? The defendant had specific recollections of things. He was able to make decisions. Extreme mental or emotional disturbance. If that was the case, he would have stabbed his son when he approached over and over again. He would have attacked his father if he was in these crazy states. Thank you, Judge. I submit to you, ladies and gentlemen, this was not proven, and there's no evidence of it. Certainly it's up for you to decide. You heard the testimony of Dr. Olander. Mind you, not a board-certified doctor. And the defense, made a big deal that, it's not, you don't need to be. Dr. Demery spent 7 additional years becoming board-certified in neuropsychology. That's a consideration for you. You're allowed to. The defense also, as a mitigator, wants that he acted under extreme duress. So the definition of duress is defined as an external provocation such as imprisonment or the use of force or threats. I would submit to you, ladies and gentlemen, there's absolutely no evidence of that in this case. Was there any threat by anyone there to imprison him if he didn't stab and kill his wife? Was there any force or threat by somebody else, an external force, saying, if you don't go stab your wife and kill her, I'm going to kill you? No, not at all. So I submit to you, ladies and gentlemen, this mitigator has not been proven. There's no evidence of it. Certainly up to you, but I submit that there's no weight. Even if you find that there should be some weight given to those, I submit in the context of what occurred in this case and his previous violent felony, it deserves little weight if you decide to give it any weight at all. And we'll just quickly, Dr. Demery, this was not a rage murder, not overkill, not under the influence of extreme mental and emotional distress, calmly committed it, no sleep deprivation, and he based that on the interviews, videos, and reviewing stuff. You take that for what it is, ladies and gentlemen. You heard the testimony, you can judge it. Let's go to our weighing factors now. Step 1. Has the state proved any of the aggravators beyond a reasonable doubt? Absolutely. I submit to you all 4 of them have been proved beyond a reasonable doubt. So then we go to the next step. Are those aggravators enough to recommend the death penalty? Absolutely, ladies and gentlemen. We go to the next step. This next step is you weigh the aggravators against the mitigators. And I took you through the mitigators, ladies and gentlemen. You heard them all. Those mitigators, in comparison to the aggravators, are far outweighed by the aggravators. Not just far outweighed, but it's just a mountain outweighed in this case. The way and manner in which he killed her, the heinous, atrocious, and cruel. And mind you, remember I said we only have to prove it was heinous or atrocious or cruel? I submit to you in this case, ladies and gentlemen, it wasn't just heinous, atrocious, or cruel. It was heinous, atrocious, and cruel. All of those. The fact that previously in 2022, he beat her in front of her son in a violent felony, made him watch. The fact that he was on probation, and the fact and the manner in which he cold, calculated, committed this murder, those far, far outweigh any mitigation in this case. That's step 3. Mitigation is way outweighed by aggravation. We go to step 4. Should the death penalty be imposed or recommended to the court? I submit to you, ladies and gentlemen, absolutely. In this case, when you look at those aggravating circumstances, when you look at what they are, this is a case where the death penalty is appropriate. When you kill your wife like that, and you stab her over and over and over again, she's pleading for her life. She can't breathe. She knows she's going to die. Is that a factor that would warrant the death penalty? Absolutely, ladies and gentlemen. The fact that he pulls an 11-year-old out of his room, brings him to the kitchen, makes him watch as he beats his mother, is that a factor that warrants the death penalty in this case, ladies and gentlemen? I submit to you it does. The fact that he's on probation at the time for an act against Ms. Williams. I submit to you the death penalty is appropriate in this case, ladies and gentlemen. In just a little while, you're going to go back into the jury room. You're going to deliberate. As I said, the aggravating factors far outweigh the mitigating circumstances. And there's no doubt, ladies and gentlemen, when you find that, I ask not 5 of you, I ask not 6 of you, I ask not 7 of you, I ask not 8 of you. I ask not 9 of you, I don't ask 10 of you, I don't ask 11 of you, but I ask all 12 of you. All 12 of you to return a verdict of death. The aggravating factors have great weight. What he did was horrific, and it was unjustified. This case, ladies and gentlemen, is about a human being. They lived on this earth. They had a life. They had years on this earth. They had a family, they had friends. And they are dead, and that is Yolanda Williams because of him. This case warrants the death penalty. And this is not going to be an easy decision. Easy decisions in life, that's not what we have here. But difficult decisions often happen, and they're hard. No one's going to take that lightly. But in this situation, I'm going to ask that you have the courage and bravery. Make the hard decision in this case. Make the right decision in this case. And vote to recommend the death penalty for Jermaine Williams for the murder of his wife. Thank you.